I appreciate that, but I think the issue was Mr. Garcia Pena had a capias. He got to first appearance. The first appearance judge said they appointed the public defender, even though he had private counsel. So private counsel didn't get notice until I mentioned it on Monday, and then so they didn't know to get an interpreter, I guess. All right. Sorry. All right.
Date that for you.
We're back to Mr. Garcia Pena.
Yes, Your Honor.
Do you have a court interpreter here for Mr. Garcia Pena, who's previously been sworn?
Yes, Your Honor. All right, Your Honor, so this is Mr. Garcia Pena. I've gone over this agreement extensively with him, gone over all the rights that he's waiving as a result of taking this plea. I've gone over with him the fact that it's going to be a withhold of adjudication. And with that, he does agree to enter this plea, Your Honor, if I may approach.
Yes. All right, Mr. Garcia Pena, I've already sworn you in earlier, correct?
Yes.
Okay. All right, you're here in 25 CF 485, where you're charged with possession of a controlled substance, counterfeiting license plates, both of which are third-degree felonies, punishable by up to 5 years in state prison. You also have 2 counts of possession of drug paraphernalia, which are first-degree misdemeanors, and punishable by up to a year in county jail. You also have a charge of driver's license suspended or revoked, which is a second-degree misdemeanor and punishable by up to 60 days in county jail. Do you understand your charges?
Yes, ma'am. Yes.
Yes.
All right, I've been handed a plea and sentencing agreement that would call for you to plead no contest to all of those charges. I'm sorry, let me rephrase that. You'd be pleading to counts 1, 2, and 3, so that's the possession of the controlled substance, the counterfeiting license plates, and 1 count of possession of paraphernalia. On the misdemeanor paraphernalia, be time served and a withhold of adjudication. On the 2 felonies, that's counts 1 and 2, it would be withhold of adjudication, 2 years probation, a substance abuse evaluation, and any recommended treatment. The probation would be concurrent for each of those counts. $615 in court costs, $150 cost of defense, and a waived cost of supervision. Is that what you want to do here today?
See.
Yes.
All right, have you had enough time to go over this form with your lawyer?
See.
Yes.
All right. Were you able to understand it even though it's in English?
See.
Yes.
All right. Did your lawyer answer all of your questions?
See.
Yes.
Are you satisfied with your lawyer's advice and representation?
See.
And is this your signature on the agreement?
See.
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
No.
Are you currently suffering from any mental health issues?
No.
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
No.
Has anyone promised you anything in return for your plea?
No.
No.
You understand by entering the plea there won't be a trial of any kind?
See.
Yes.
Do you understand that by waiving your right to a trial, you give up your trial rights, which are listed in the agreement you signed?
Sí.
Yes.
Do you have any questions about those rights?
No.
Do you understand you're waiving any potential defenses that you may have?
Sí.
Yes.
Do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the United States of America?
Yes.
And do you understand that even though this is a withhold of adjudication, the federal government, including immigration, would consider them a conviction for immigration purposes?
Sí.
Yes.
Given that advisement, how do you wish to plead to the possession of controlled substance, counterfeiting license plates, and possession of drug paraphernalia?
No me opongo.
No contest?
I'll accept your no contest to counts 1, 2, and 3. Does the state have an announcement as to counts 4 and 5?
Yes, Your Honor, the state will be null processing those 2 counts.
I'm sorry, Your Honor, if I may. There is a hold on him, so it probably should, his probation should start upon his release from that hold, or from wherever he's sent to.
Okay. Mr. Garcia Pena, do you understand your probation will not start until you're released from incarceration?
Sí.
Yes.
It's going to be a withhold of adjudication on counts 1 through 3. Count 3 will be just time served. Counts 1 and 2, 2 years of concurrent probation. Also a withhold of adjudication. You're to successfully complete a substance abuse evaluation and any recommended treatment. Pay $615 in court costs, $150 cost of defense, and waive cost of supervision. Anything that I've missed?
No, Your Honor, thank you.
Nothing, Your Honor.
This is a guideline sentence as he scored 16.9 points. I need to speak with probation, and you have 30 days to appeal the judgment and sentence of the court.
Thank you very much.
Thank you. Can you help out with him speaking to probation?
Your Honor, just so the court is aware, probation has, ICE does not communicate with probation. So with the understanding that if they pick him up, we may never see him again.
Okay.
I don't think it's an ICE hold. I think the hold is for another charge in another state.
That was my understanding of from previous dealings with the case.
Yes, Your Honor.
So I just wanted the court to understand that you may be seeing a VOP come pretty quick just because we can't find him.
I understand. And I think I just signed a VOP warrant on someone who had been deported because I wanted to make sure that was in. Otherwise, there's waiving, tolling, and all that sort of stuff.
I just didn't want you to see it and think, what are y'all doing?
I appreciate that.
Mr. Barry, if I think you've done something wrong, I have to recheck because you're usually right.
You can call him.
All right, let me bring up, we've got Mr. Kane and Mr. Maddox.
Yes, Your Honor.
Let me bring in the jail.
And I previously provided a copy of the report to the court, right?
Oh, the competency evaluation?
Yes, Your Honor.
Yes, I've reviewed it.
Excellent.
Your Honor, give us 1 second, we'll have him in here.
All right, thank you. Sorry we're running a little bit late.
Yep, stay right there on that edge.
Morning, sir. Can you tell me your name?
Kane.
Is it Kenneth Kane?
Yeah.
All right, Mr. Kane, you're here in 25 CF 782. Your lawyer, Mr. Maddox, is present here for you in court.
Hey, Mr. Kane.
Please right there.
Okay.
Oops.
Your Honor, I believe the state and I are stipulating to the court making its findings based on that report.
That is correct, Your Honor.
Why is that moving so much? All right, so I have read the competency evaluation report from Mr. Kane. Based on the stipulation that the court can make its decision based on that evaluation, I'm going to find that Mr. Kane is incompetent to proceed. And also based on the recommendations of the report, I'm going to find that he's going to be placed in the custody of the Department of Children and Families to go to the Florida State Hospital for purposes of competency restoration.
All right, thank you, Your Honor.
Thank you, Your Honor.
Anything else from Mr. Kane?
No, Your Honor.
Please send me the order.
I will.
All right, thank you, Mr. Kane.
Or my
Mr. Kane.
back in.
Thank you, Your Honor.
All right, appreciate y'all. Have a good day.
All right. I've got some lined up with the family here.
Okay.
So, Ms. Rivers, if you're ready on Shanklin, I think is yours.
Yes, Your Honor. Yes.
Shanklin.
He's got demoted.
I don't want that.
Your Honor, this is Bryson Shanklin before the court on 25 CF 556. We are going to request a continuance to the next pretrial conference date. If the court will recall, at our last pretrial conference, we were in the process of securing a different expert. We did secure that expert, and I've already had 2 meetings with him. There was some additional information that he needed, and he was reaching out to the police to see about getting that information. Things are going along a lot faster now, and we're asking for the continuance to the June court date.
State, any issue? Okay.
And we still have a pending evaluation by Dr. Harper, but that is scheduled for the month of May.
And the expert you were referring to is on the forensic?
That's correct, Your Honor.
Okay. All right, June 24th, 9 o'clock.
And then Ms. Rivers, there's somebody here for Rush.
Say Rush?
Rush, Tyrone.
Hello, baby.
Tyrone Rush, 25 CF 2475.
Your Honor, we have reached an agreement in this matter, if I may approach.
If it's a 4th, shouldn't it be a permanent revocation? Good thing I've got the statute pulled up already. All right, Florida Statute 322.28. Paragraph 2, subparagraph D. The court shall permanently revoke the driver's license or driving privilege of a person who has been convicted 4 times for the violation of 316.193 or former 316.1931. Y'all want to have a discussion about that? My concern is not only do I have to make sure you understand it, you also have to understand that even if I didn't impose it, DMV will do it. Do you understand that, Mr. Rush?
Yeah.
Okay. So I'm going to cross this off on your plea and sentencing agreement. And put lifetime revocation of driver's license. I'm going to ask you some more questions about that, Mr. Rush, but I just wanted to make sure before we go forward that you don't want to have to spend some more time talking to Ms. Rivers about that.
Proceed.
All right. All right, Mr. Rush, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, make sure she's speaking to that microphone. If you just move it for a little bit. It's just hard for you to move it. I want to make sure that she's moving it for you. You're good. You're good now. All right, can you state your full name and date of birth, please?
Tyrone Rush,
Okay, and Mr. Rush, you're here, I'm sorry, your date of birth?
4/27/77.
And Mr. Rush, you're here in 25 CF 2475 where you're charged with DUI fourth or more conviction, which is a third-degree felony and punishable by 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would call for you to plead no contest to that charge. In return, the agreement between you've made with the state calls for an adjudication of guilt, 11 months, 29 days in Okaloosa County Jail, followed by 3 years of probation. There'd be a $4,000 fine, waive costs of supervision. I think court cost is going to be more than that. Can you give me the court costs on that, Heather? $100 cost of prosecution, $100 PD fee, $50 application fee. It says DUI school, but that would be multiple offender DUI school. $100 of community service. A lifetime revocation of your driver's license is again as required by statute. And that would be a felony conviction for you, Mr. Rush. Do you understand that? So I think under 316.193, it also requires a 90-day impound of the vehicle. Issues with that, Mr. Rush?
No longer had a car anyway.
Okay, I have to give
Yeah.
you, and then you'll deal with DMV potentially about that.
Yeah, okay.
You just have to prove that you don't have the vehicle anymore. They may try to push it on if you ever get another vehicle, but that's in your name. And frankly, although I say it's a lifetime revocation, I believe there still is a way through certain methods to get a license. It's got to be, I think, at least 10 years. It's been a long time since I've handled some of these DMV issues because we don't handle a lot of DUIs in circuit court. It's usually in county court. But I just want to make sure I'm telling you the most information that I can, but I can't give you legal advice on those things. I'm just trying to point out certain things to you. However, if you are ever found to be driving on this type of lifetime revocation, it is a felony. Do you understand that? Do you understand that? Okay. All right. Have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
All right. And did you understand and sign the agreement? Are you satisfied with your lawyer's advice and representation?
Sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement?
No.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
And do you understand that you're waiving all your rights to trial and your trial rights, which are listed on page 1 and going on to page 2 of the agreement that you stated you understood and signed? And do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? Given those things, Mr. Rush, what is your plea to the felony DUI?
Contest.
Accept your no contest plea is freely, voluntarily, knowingly given, adjudicates you guilty, sentence you to 11 months, 29 days in the Okaloosa County Jail, followed by 3 years of probation, $4,000 fine, waive cost of supervision, court costs.
$683 plus the $200 surcharge.
All right, $683 in court costs plus the $2 surcharge. That's based on the amount of the fine. $100 cost of prosecution, $100 PD fee, $50 application fee, multiple level DUI school, $100 of community service, lifetime revocation of your driver's license, 90-day impound of your vehicle. Again, you'll be adjudicated guilty as a felon. You did score 37.8 points, which means you didn't score prison, so this is a guideline sentence. I didn't see it on there. Was there a contemplation of credit for time served?
Yes, Your Honor.
All right. I'll give you credit for all time served on this case. I need you to talk to probation quickly, Mr. Rush, but they're sitting there behind you. And then you have to come up to be fingerprinted. Then you have 30 days to appeal the judgment and sentence of the court.
And then I believe I have Mr. Matthews with Mr. Williams.
Judge, this is a negotiated plea. Mr. Matthews. It's 429.
Thank you, sir. All right, Mr. Matthews, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I swear.
All right, can you state your full name and date of birth, please?
William Michael Matthews, 10/15/96.
All right, Mr. Matthews, you're here on a violation of probation in 22 CF 2717 and new case failure to register in 25 CF 2248. Both are third-degree felonies punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handing a plea and sentencing agreement between you and the state that calls for you to plea as charged. It's admitting your violation of probation and pleading no contest in the new case. Be adjudication of guilt, 2 years of community control concurrent with GPS. You need to be set up and hooked up with that GPS before you're released from the county jail. Comply with all your registration requirements, complete any outstanding terms from the 22 CF 2717. Waive cost of supervision, $100 VOP fee, $515 court costs, and $150 PD fee. Is that the agreement that you've made?
Yes, Your Honor.
Have you had enough time to go over this with your lawyer? Excuse me. Did you understand and sign the agreement?
Yes, Your Honor.
And are you satisfied with your lawyer's representation and advice in this case?
Yes, Your Honor.
This appears to be a downward departure, is that right?
That is correct, Your Honor. It's an enforced plea agreement, and if the court requires additional information, I'll be happy to approach.
Please approach. All right, Mr. Matthews, are you under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've read to you? Do you understand that on the violation of probation that you have a right to an evidentiary hearing where the state would have to prove how you violated your probation? You understand you'd be giving up the right to that evidentiary hearing? On the new case, you understand by entering a plea, you'd be giving up your right to a trial. And you understand you'll be giving up your trial rights, which are on page 1 and going on to page 2 of the agreement you said you understood and signed. And do you understand that you're waiving all potential defenses in both cases? And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to the violation of probation? Are you admitting or denying you violated your probation? accept your admission as freely, voluntarily, knowingly given. And 25 CF 2248, what is your plea to the new charge of failure to register?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. As to each case will mean adjudication of guilt, 2 years of concurrent community control with GPS to be hooked up before you're released from jail. Comply with all the registration requirements, complete any outstanding terms that you have in 22 CF 2717, waive cost of supervision, $100 VOP fee, $515 in court costs, is that accurate?
666.
$666 in court costs, and the $150 PD fee. This is a downward departure based on an uncoerced plea bargain, and the reason so stated at the bench, as he scored 93.6 points. Mr. Matthews, I need you to speak with probation once he's ready for you. I do need your fingerprints. You want to do that first, Steve? Why don't we have you step up and do your fingerprints while you're waiting, then you have 30 days to appeal the judgment and sentence of the court.
Thank you, Your Honor.
Thank you.
Is he terminated or reinstated?
Reinstate to probation.
Then I had two lined up for Ms. Rivers. First one is Randy Perez. Mr. Perez. Judge, please.
Your Honor, this is Randy Perez before the court on 25 CF 949, 25 CF 2399. We've conducted depositions in the first case. We are planning on conducting depositions in the second case,
Okay.
hopefully in May or June.
Okay. So in the 949 case, depots are done?
Yes, that's correct, Your Honor.
Okay. And you still have to set more in the 2399 case?
That's correct, Your Honor.
Okay. So what are you asking for?
Continuance, Your Honor.
624 at 9 o'clock, Mr. Perez will be your next pretrial conference. Thank you, sir.
Judge, can I apologize to you for last time I was in here with my attitude, sir?
Okay. You know, sometimes I feel like maybe I shouldn't say this, but I do so many of these court dates, sometimes people like that apologize, and I appreciate that, and I accept your apology, sir. I don't always recall it. Sometimes apologizing makes me remember it. So, just a little pro tip. So. Well, I guess it also shows I don't really take a whole lot of offense to what people say or do, because it's part of my job, and I understand that. All right, Ms. Rivers, who do we have next?
Your Honor, this is Jeffrey Pope, 25 CF 1587. We previously had conducted depositions, however, the main witness speaks another language, so we have them on the list for May or June to be redeposed using language line. So we're asking for continuance to the 6/24 date.
Without objection, Judge.
Any issues with getting an interpreter through language line? Is it anything that's...
I do not know
Okay.
how far along that has gone in the process.
Just as far as, is it a difficult language, or?
I've heard of it before, but I just, I'm trying to remember now what the language was. Do you remember what I told you the language was?
Okay. I just asked because sometimes with language line, it's good to set up an appointment and contact them and set it up to make sure they have someone who can speak that language and actually knows Bengali. Okay. When I've been in other divisions in other counties, I've had people speak languages I've never even heard of, just, dialects of Central America and things like that. So it's good to set it up in advance so you've got the right person. Otherwise, they may speak it, but maybe not to the effect you need them to for such an important task. All right, so 6/24?
Yes, Your Honor.
June 24th, 9 o'clock. Mr. Pope, we'll see you back on that date after your depositions are done.
I had those two for Ms. Rivers because Lana was speaking with somebody. The rest of Mr. Maddox is lined up. So we're good. Okay, so with Mr. Maddox, he went and spoke to Mr. Allen. Allen.
Tommy Allen, right?
Your Honor, this is going to be an agreed-upon resolution. This is Mr. Allen before the court in 26 CF 238 and 24 CF 2337. May I approach, Your Honor?
Yes. All right, Mr. Allen, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name and date of birth, please?
Tommy Ray Allen Jr., 5/31/1970.
All right, Mr. Allen, you're here on a violation of probation in 24 CF 2337. Also, you have a new case, 26 CF 238, where you're charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, and possession of drug paraphernalia, which is a 1-year first-degree misdemeanor.
Yes, sir.
I've been handed a plea and sentencing agreement. I've called for you to admit your violation of probation and plead no contest to the new case on all counts. Be credit for time served, adjudication of guilt. After you admit your violations, revoke and terminate your probation. 615 court costs. Let's see, $250 cost of defense, $100 VOP fee, and all your costs monetary will go to judgment. Do you understand that?
Yes, sir.
All right, have you had enough time to go over this plea agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Have you had enough time to speak with him?
I just had one question.
Okay, you kind of look like you had a question, that's why I'm asking. Good?
Beautiful.
Okay. That's the first time someone's called me that today.
Oh,
Thank you.
yeah, so you are. I
But you
keep
tell all
telling
the
them how
judges
happy you are out here, so everybody's happy in there, happy to see you happy, everybody's happy.
Oh, boy.
I'm happy.
Glad, Mr. Allen.
Trying to turn over a new leaf. All right, Mr. Allen, are you satisfied with your lawyer's advice and representation? Okay, everybody take a breath, including me. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Yeah, I understand this.
No, sir.
Okay. Are you suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I read to you?
Oh, yeah. No, sir.
Okay, and as far as the violation of probation, do you understand you have a right to an evidentiary hearing where the state would have to prove how you violated your probation?
I understand.
Do you understand by admitting your violation, you're giving up a right to that hearing?
Yes, sir.
And do you understand by pleading no contest to the new case, that you're giving up your right to a trial?
Yes, sir.
And you're giving up your trial rights, which are on page 1 and going on to page 2 of the agreement you signed and said you understood.
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
And finally, do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right. Given that, on the violation of probation, Mr. Allen, are you admitting or denying your violation?
Admitting.
Okay. And on the new case, what is your plea to the possession of controlled substance and possession of drug paraphernalia?
No contest.
All right, I'll accept your no contest plea and your VOP admission as freely, voluntarily, knowingly given. It's going to be credit for time served, adjudication of guilt, revoke and terminate your previous probation, 615 court costs, $250 in cost of defense, $100 VOP fee. All of your costs and monetary will go to judgment against you, Mr. Allen, which just means like a civil lien against you like any other unpaid debt. I need you to be fingerprinted because it's a new felony charge, new felony conviction. And then I need to tell you that you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence as he scored 31.20 points. Good luck to you, Mr. Allen.
Thank you, sir.
And I do believe you'll need fingerprints in the VOP as well, as I believe it was previously a withhold.
Okay. All right, fingerprints all around.
Mr. Cooper?
All right. Go ahead, Mr. Maddox.
Yes, Your Honor, this is Mr. Cooper.
Malik Cooper.
Yes, Your Honor, 25 CF 2245. Did I provide the court a copy of this competency evaluation?
I received it via email, I believe, yesterday or the day before. I've read it previously online, not online, in my email.
Yes, Your Honor, I do believe both the state and I are stipulating that you may make a determination based on this report.
That is correct, Your Honor.
All right, and I've previously reviewed the report by Dr. Zeman, dated March 3rd, 2026. Based on the stipulation, I'll make my determination based on that report. I do find that Mr. Cooper is not competent to proceed at this time, and place him with the Department of Children and Families for placement in a psychiatric treatment facility, forensic psychiatric treatment facility such as Florida State Hospital, for his competence restoration.
Yes, Your Honor, I'll get you that order.
All right, thank you, Mr.
I got time receipt?
No, you're incompetent, you're sent to the board. Yes, sir. No, but as soon as they can.
Am I going home today?
Yes, sir.
What is that?
Should be soon.
Preach.
Blue mark on the floor, please, Judge, please.
Your Honor, this is Mr. Creech before the court in 26 CF 127. Your Honor, I am still awaiting a competency evaluation in this case, and it is first time up. I am asking for a continuance.
All right, June 24th, 9 o'clock.
Thank you, Your Honor.
June 4th?
June 24th.
June 24th?
Yes.
Georgia Daniel on the way.
With Ms. Daniel's case, or Ms. Daniel's case, Your Honor, it'll be a agreed upon resolution. The state hasn't filed on a new case, and they're going to announce a no pros on that case.
Methamphetamine and paraphernalia case.
Possession of controlled substance and paraphernalia case, yes, Your Honor. 26 CF 615.
I'm very short, you gotta move it closer. Today.
Your Honor, may I approach?
Yes. Thank you. All right, Ms. Daniel, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth, please?
Georgia Daniel, 053004.
You can put your hand down, Ms. Daniel, thank you. You're here on 25 CF 1446, charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, and also 26 CF 615, another charge of possession of controlled substance, 5 years maximum, and possession of drug paraphernalia, first-degree misdemeanor, punishable by up to a year in county jail. Do you understand all that?
Yes, sir.
I've been handed a plea and sentencing agreement that would call for you to plea as charged in the first case, 25 CF 1446, be 2 years probation, a withhold of adjudication, Substance abuse evaluation, any recommended treatment. 615 court costs, 150 cost of defense. I waive cost of supervision for you. In return, the state has agreed to dismiss your new case, 26 CF 615.
Thank you.
Is that what you want to do today?
Yes, sir.
All right, and have you had enough time to go over this agreement with your lawyer?
Yes.
Did you understand and sign it?
Yes.
Are you satisfied with your lawyer's advice and representation?
Very.
I was waiting for your response, Mr. Maddox. All right, and are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way?
No.
Has anyone promised you anything other than the terms of the agreement I've just read to you?
No.
Do you understand by entering a plea there won't be a trial of any kind?
Yes.
Do you understand that you'll be giving up your trial rights which were contained in the agreement you signed and said you understood?
Yes.
Do you understand you're waiving all potential defenses that you may have?
Yes.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes.
All right, Ms. Daniel, how do you plead to the one count of possession of a controlled substance in 25 CF 1446?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement in 26 CF 615.
Yes, Your Honor, based on that plea, the state will no pros 26 CF 615.
Is that set for tomorrow?
It
Yes,
is.
Your Honor.
Okay, make sure we take that off the docket for tomorrow. All right, that case is dismissed on the 25 CF 1446, withhold of adjudication, 2 years probation, substance abuse evaluation, any recommended treatment, 615 court costs, 150 cost of defense, and a waive cost of supervision. Ms. Daniel, I need to speak with probation, who's sitting there behind you. And then you have 30 days to appeal the judgment and sentence of the court. You scored 16.2 points, so this is a guideline sentence. Thank you, Ms. Daniel. Good luck.
I do have an information in the
Oh, there is an information in the case for tomorrow, so it would be a null
Oh,
pros.
it would be a no, yes. Okay.
Very important letter, I guess.
I think that might have been the one I did last minute.
That's fine. We just want to make sure it's all accurate. Who do we have next?
Mr. De La Rosa.
All right, this is Andrew De La Rosa, 24 CF 1700.
Yes, Your Honor. Ms. Basso and I and Mr. Kleins were able to go review the text messages on the phone. I am going to request a report for those text messages, so just for the text messages is what I'll do. And review that with Mr. De La Rosa. But I don't anticipate anything else needing to be done, Your Honor. So we are going to try and put this in a position where we either plea it or go to trial next cycle.
Okay. All right, anything else from Mr. De La Rosa?
No, Your Honor. You have anything? Okay.
June 24th, 9 o'clock for pretrial. We expect this will go next time if it doesn't resolve.
Yes, Your Honor.
All right, thank you, sir.
Search warrant? Yes, I'll bring that to you. Your Honor, this is Mr. Denman.
It's 25 CF 1343.
Yes, Your Honor. If we could put this on May 4th for a plea or trial.
State ready for trial?
State's ready for trial.
Okay. All right, Mr. Denman, we'll see you on Monday, May 4th. It's going down as plea or trial. Is that, oh, hold on just a second. He's got a new case. I'm assuming that would be on the 25 case.
Yes, Your Honor. The 25 CF 1343 is the one that we were setting plea or trial. 26 CF 288, we just got discovery on that, I think, on April 17th, Your Honor. Is that actually set for today, the 29th?
It's on my
Case?
docket.
Okay, I will ask to continue that case, Your Honor.
All right. Well, why don't we just put it out for plea or continue for Monday, and then we'll address it from there.
That works. Yeah. You all right? Your Honor, this is Mr. Enzbacher before the court in 23 CF 1532. If we could put this on May 4th for plea or continuance.
Without objection.
I'm optimistic of a possible resolution, but we'll see.
All right, May 4th, plea or continue?
Yes, Your Honor.
All right.
Just to advise the court on status of leading up to that, we did have depositions set in this case. The alleged victim is in Alabama. She's in the hospital. She's not doing well, not because of the injuries alleged here, but other issues. So we weren't able to serve her. There was one officer we did get, but he was on Zoom. He no longer works with Crestview PD. He was not given access to his body camera or to his report, so we went ahead and canceled that deposition because that was the only deposition that was going to move forward. So given we don't resolve this case, I'll get those all rescheduled, Your Honor.
Okay. All right. But we're putting it on for Monday.
Yes.
All right. 5 for 9 o'clock.
Thank you.
Fiducia.
Your Honor, this is Mr. Fiducia before the court in 26 CF 202. Your Honor, if we could put this for plea or continuance on May 4th.
It's the first time up, May
Yes, Your Honor.
4th, plea or continuance. See you back on Monday, Mr. Fiducia. You too.
Fonseca? Come out, please, sir.
Your Honor, this is Mr. Fonseca before the court in 25 CF 1972. Depositions are set for June 17th. I am asking for a continuance.
Without objection, Your Honor.
All right, Mr. Fonseca, we'll see you back on June 24th for a pretrial conference. But I know you've got depots set. Let's do your best to finish those up and see if that case can be resolved next cycle.
Yes, Your Honor.
Foster.
Yes, sir. Your Honor, this is Mr. Foster before the court in 25 CF 2026. Your Honor, I am working to get depositions set in this case, so I would ask for a continuance to next pretrial conference.
Has there been some barrier to setting those depositions?
No, Your Honor. I decided that I would take depositions in this case fairly recently, and I sent that out, so we're just waiting on dates from the state, and I'll make sure to coordinate that and get those set.
Your Honor, this is Ms. Lamony's case, so I can't offer updates, but I will verify that that is in coordination.
Okay.
It's from October, so let's make sure depots are getting set, just because, as we all know, it often takes a round or 2 or 3 to get all of them done. I just want to make sure that's being pursued.
Yes, Your Honor.
All right, June 24th, 9 o'clock for pretrial.
Mr. Daney. Come on out, please, sir. Stand on the blue mark on the front, please.
Good. Your Honor, this is Mr. Gainey before the court in 26 CF 146. Your Honor, it is the first time up. I am asking for a continuance.
Without objection.
June 24th, 9 o'clock, pretrial conference. We'll see you back on that date, Mr. Gainey.
Gary? Gary? Come on in now. Stand on the mark in the corner. Return to this judge.
It's Gary.
Gary.
Heather Gary, 26 CF 465. How was this case on this docket already?
Your Honor, if I could put this on May 4th for plea or continuance. And this is Miss Gary before the court in 26 CF 465.
All right.
No
Mr.
objection
Sheik.
from the state, Your Honor. I was just going to let the defense know that we actually just received the lab report 25 minutes ago, so we'll send that in amended discovery tomorrow, probably.
Okay.
All right, May 4th, plea or continue.
From FDLE.
I shouldn't even been arrested to begin with. You're taking too long, man. No, you right.
All right, thank you, Miss Gary.
Gizclair.
Mr. Gizclair, you said?
Yes.
Okay. Just got the screen after that, that's it. Awesome. Your Honor, do you have a copy of the report for Miss Green? It was from the APD.
Not that I recall. Oh, is this it? I've got Dr. Klein's report.
Yes, Your Honor, that's the one I'm referencing.
Okay. All right, who's this?
This is Mr. Gizclair, Your Honor, 26 CF 389 and 26 CF 390. I am asking for a continuance, Your Honor. It is the first time up.
Without objection, Your Honor.
All right, June 24th, 9 o'clock. June 24th, 9
Yes, Your
o'clock.
Honor. Thank you.
All right, thank you.
I'm sorry, I missed it.
It's okay.
And Mr. Sheik, I gave you a copy, correct?
Yes.
Okay. Are you stipulating?
Yes.
Okay.
Come on.
Miss Green. Your Honor, this is Ms. Green before the court in 25 CF 494 and 25 CF 1817. The state and I would agree to stipulate to the court making its findings based on the report provided from the Agency for Persons with Disabilities.
That is correct, Your Honor.
And that's the Klein report?
Yes, Your Honor. Dr. Klein's report.
I'll just put on the record, I've also reviewed Dr. Siemens' report, which was filed back in December.
Yes, Your Honor.
That led to us getting the second report.
Correct.
I've also reviewed Dr. Klein's report. Based on your stipulation, I'll use that report to make my determination. Ms. Green is incompetent to proceed and will be What's being recommended is for the APD program, the Development of Disabled Defendant Program at the Florida State Hospital. Anything else?
No, Your Honor.
All right. Do we need any follow-up date for her?
Yes, since we have had difficulties getting people there, I guess I would suggest that, Your Honor, perhaps May 28th, a miscellaneous date.
Okay. I don't think it's going to happen by then, but let's hope.
Yeah, just keep tabs on it, Your Honor.
Let's just put it as May 28th at 9 o'clock, just to kind of keep tabs on whether they've picked her up.
I will reach out to...
Based on what we've talked about earlier and what I've heard since, I'm a little concerned about how long it's going to take, but I can address those issues when they're brought to my attention.
Yes, Your Honor, and I will reach out to Mr. Sanchez and get an estimation if possible.
Okay. I know this is slightly a different program than we normally are talking about, but I'd like to keep my thumb on it the best I can, because I don't always get great information unless I go out and seek it, and even then, it's not always easy.
Yes, Your Honor, I agree.
All right. Thank you, Mr. Maddox.
All right, thank you, Your Honor.
I don't believe they gave me Miss Pennington. You still need some time to talk to her.
Okay.
Hello there. Your Honor, this is Zacharias Porter before the court on 26 CF 334. We're in the process of getting 2 different evaluations done. They have not been done at this time, so we're going to request a continuance to 6/24.
Okay. Are they set in any way?
I'm sorry?
Are the evaluations set?
I don't know. I know one of them should already be set. The second one, it's harder to find a person to do that type of evaluation, so I don't believe that's been set.
All right, June 24th, 9 o'clock. This is the first time up.
That's next month, ain't it?
Another month.
And ain't sweating.
Mr. Quillin.
Your Honor, Mr. Quillin is going to need a minute to sign a plea agreement.
Okay.
Oh, you got it? That explains why.
Thank you. All right, Mr. Quillin, can you raise your right hand? Sorry, I'm just reading through all this. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your full name and date of birth, please?
Christopher Lee Quillin, 1976.
All right, Mr. Quillin, you're here in 26 CF 128, where you're charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, paraphernalia, first-degree misdemeanor, 1 year county jail, fleeing attempt to elude, third-degree felony, 5 years maximum prison, resisting without violence, 1 year maximum on a first-degree misdemeanor, attaching tag not assigned, driver's license suspended, no valid registration, and failure to have insurance. Those last four are all second-degree misdemeanors and punishable by up to 60 days in jail each. You also have 26 CF 138, which is fleeing to elude, third-degree felony and driver's license suspended, first-degree misdemeanor. Do you understand all your current charges? Yes?
Yes, sir. Yes, sir.
Okay. All right, I have a plea and sentencing agreement between you and the state where you've agreed to plea to the 26 CF 128, 3 years probation on the felony counts, credit for time served on the misdemeanors. Court costs would be traffic related, so what is it, 540 something?
548.
548. $100 cost of prosecution, well, that's part of it. So $548 in costs, $100 PD fee, $50 application fee, waive cost of supervision, substance abuse evaluation, any recommended counseling, or you can complete the ECLC Emerald Coast Life Center program instead, comply with. Your driver's license will be suspended for a period of 1 year, and in return for that, the state has agreed to dismiss 26 CF 138. Is that what you want to do today?
Yes, sir.
Is that the state's agreement? Yeah. All right, have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
And did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
Yes, sir.
Has anyone promised you anything other than the terms of the agreement I just read to you?
Yes, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are on page 2 of the agreement that you've signed?
Yes, sir.
And do you understand you're waiving all potential defenses?
Yes, sir.
All right, and do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea as charged in 26 CF 128?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. The state have an announcement in 26 CF 138.
Yes, the state announces a null pros.
Okay, that case has been dismissed. In 26 CF 128, 3 years probation on the felony counts, credit for time served on the misdemeanors, $548 court costs, $100 costs of defense, $50 application fee, waive cost of supervision. You're gonna have to complete a substance abuse evaluation, any recommended treatment, or comply with the ECLC program. Driver's license will be suspended for a period of 1 year. This is a guideline sentence as scored 42.60 points. I will mention to you, Mr. Quillin, even a technical violation of your probation would give you 6 points.
Yes, sir.
That puts you over the limit for then scoring prison. Do you understand that?
Yes, sir.
So if you don't check in with your probation officer, don't do something they've instructed you to do, you don't tell them the truth, you could be looking at a prison sentence. Do you understand that?
Sure.
All right. I need you to speak with probation who's sitting there behind you. I need your fingerprints. This is an adjudication of guilt. And then you have 30 days to appeal the judgment and sentence, Mr. Quillin.
648 possession charge.
648 court cost because of the possession.
And the felonies, are they concurrent?
Concurrent probation. Oh, and one more page on the back end of that plea and sentencing agreement.
So, since it's not, Your Honor, this is Jared Riley before the court on 22 CF 1745, 25 CF 1707. Your Honor, we have finished reviewing all the discovery, all the videos. We now need to set depositions, and so we're going to request continuance to the 6/24 docket.
Without objection, Your Honor, and as always, just send me some dates, we'll get it.
June 24th, 9 o'clock.
all of the females together. The first one out the door will be Miss Pennington. I think is her name, right?
Haley Pennington, the DUI one.
Okay.
Thank you, Ms. Rivers. This weird paper clip on here. Do you want that back? I don't know, it looks, I'm not sure what it is, but, it's a cat. I was looking at it upside down.
That's what it was.
Oh. All right, Ms. Pennington, can you raise your right hand? I think we may have already done some of this, but we'll start from scratch. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Haley Danae Pennington, 51193.
You can put your hand up. All right, Ms. Pennington, you're here in 25 CF 2446, as well as 25 CF 2222 and 2223. I have a plea and sentencing agreement that would have you plea as charged, so that's possession of a controlled substance, 3 different counts, possession of drug paraphernalia or drug equipment, first-degree misdemeanor punished by up to a year, 2 counts, and then the DUI in 25 CF 2446 is a specified traffic offense and punishable by up to 6 months in county jail. Do you understand your current charges?
Yes, sir.
All right. The plea agreement calls for you to plea as charged, adjudication of guilt on all cases, all counts. They all run concurrently, credit for time served on the misdemeanors. On the felony counts, be 24 months of community control with the following conditions. You're going to go to and complete the Phoenix House program. That's bars to bed, which means you'll stay in the county jail until they're ready to pick you up. Have y'all talked about timeline on that?
We don't know because Phoenix House no longer will put you on the list until after you're sentenced and they receive a certain form from probation.
Okay. Cost of supervision would be waived. On 25 CF 2222, it would be $515 court costs, $100 PD fee, $50 application fee. In 2223, it would also be $515 plus a $100 PD fee. In 25 CF 2446, it'd be on the DUI, maybe $500 fine. $476.63 in court costs. $50 public defender fee.
683.
$683.
Plus 100 for the possession charge, 783.
783. Because she's pleading to the felony on that case too, right? The 2446. Okay. Driver's license will be suspended for 6 months. DUI school, 50 hours of community service, 10-day impound of the vehicle, victim impact panel, all of your DUI sanctions based on what we discussed before. I'm sentencing you to them. But because you're going to the Phoenix House and you won't be able to do those sanctions on your community control while you're there, I'm going to what's called D6 those requirements, which means in order to get your driver's license back, you're going to have to complete them. So as probation kind of somewhat suggested, is that at some point DMV will be supervising to make sure you're getting these things done. As I'm sentencing you now, just be after you're out of the Phoenix House and have completed that.
Yes, sir.
You understand all that, Ms. Pennington?
Yes, sir.
I know it's a little confusing sometimes, but when we're trying to fashion certain remedies and punishments and rehabilitation, we have to be a little creative on how that works sometimes. All right, have you had enough time to go over the plea agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's representation and advice in this case?
Absolutely.
I'm sorry, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way?
No, sir.
Has anyone promised you anything?
No, sir.
You understand by entering the plea that there won't be a trial of any kind?
Yes, sir.
You understand you're giving up your trial rights, which are on page 2 of the agreement that you've signed? And you understand that you're waiving all potential defenses?
Yes, sir.
And do you have any questions about those DUI sanctions and the D6 suspension?
No, sir.
Okay. And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And how do you plea as to the 3 counts of possession of controlled substance, 2 counts of drug paraphernalia, and the DUI?
No contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given. On the felonies, it's going to be 24 months of community control, bars to bed with Phoenix House, cost of supervision is waived, adjudication on all counts. On the misdemeanors, it'll be credit for time served. However, on the DUI in the 2446 case, $500 fine, DUI school, 50 hours of community service, 10-day vehicle impound, victim impact panel. Those DUI sanctions will be D6'd, but you have been sentenced to them. On the 2222 case, 515 court costs, $100 PD fee, $50 application fee. In the 2223 case, 515 plus 100 and 100. Oh, I'm sorry, no, 515 plus the $100 PD fee. And then on 25 CF 2446, there's that $500 fine, and then what did you say, 783?
783, and it'll be 615 on the other ones.
Oh, so 615 on each of the first 2, and then 783 on the third. $50 public defender fee. There's also the 6-month suspension of your license. I don't think I have to D6 that one. It has to be reinstated. This is a guideline sentence, as she scored 35.20 points. I do need you to speak with probation once they're available. While you're waiting, why don't you go and come up and be fingerprinted? Then you have 30 days to appeal the judgment and sentence of the court. Thank you, Ms. Pennington. Good luck with everything.
Ready for you. And then I have Ms. Saunders. Saunders?
Your Honor, this is Shiloh Saunders before the court, 25 CF 1830. There's currently an evaluation pending with Dr. McDonald. The court had ordered a second evaluation, and so we're just waiting on that. So we're going to request a continuance to 6/24.
All right, 6/24 at 9 o'clock. Thank you, Ms. Saunders. Doctor will come see you soon.
And then Ms. Sexton.
Your Honor, may I be excused?
You have nothing else?
I don't think so, Your Honor.
Are you sure?
I'm pretty sure.
So I'm going to dump about half my cases on him.
Okay.
I'll double check with the clerk.
Your Honor, this is Risa Sexton, 26 CF 359. This is her first time up. We have reviewed the discovery together. We're going to need to set depositions. So request to continue it to 6/24.
All right, 6/24, 9 o'clock. This was the first time up. Set depos. All right, thank you, Ms. Sexton. Ooh.
Okay, we get Robinson 93, which is 93 down.
Enjoy your afternoon, Mr. Maddox.
Everybody's here. Stand on this blue X on the floor. Yes, Judge, please.
Your Honor, this is Anthony Robinson before the court on 26 CF 292. There was a lot of confusion in the past about his particular case, his status, where he was, and it was later learned that the Department of Juvenile Justice had taken custody of him. Your Honor, he is back in the county jail, though, and he does have another case pending, 26 CF 703. That being said, we're going to request a continuance in this case to the 6/24 docket to see if we can't resolve both these cases together.
That's without objection, Your Honor.
All right, June 24th, 9 o'clock.
Okay.
All right, thank you.
Rogers.
Robinson is also set for tomorrow.
Your Honor, this is Herbert Rogers.
Hold on
before-
just a second. Robinson is set for status on which case?
On tomorrow for.
Oh, I don't think we need another status on him now that he's here. So we can cancel him tomorrow.
Yeah, when we get done.
Mr. Robinson was also set for tomorrow for status. I think it was just what you said, bringing him back from DJJ.
That's correct.
All right, so we can cancel tomorrow?
Yes,
So
Your
we're
Honor.
canceling them all?
Yes.
No,
No,
not you.
Mr. Robinson.
Oh,
Mr.
I was like,
Robinson.
well.
I don't even know what tomorrow is for you.
Your Honor, this is
Tomorrow is
Herbert
going to happen.
Herbert
Thank you.
Rogers. He's before the court on 26 CF 82. He also has a new law of 26 CF 600. We are going to request a continuance at this time to the 6/24 docket.
Oh,
That's
Two-
his-
two
that's-
months away?
That's his next docket.
why do we have to wait so long? Is there a way you can speak to the DA and try to get a global resolution
Yes.
and do probation or something?
This,
I just don't want to wait 7, 8 months in the county for a time served and then it just be, because once you look at all the stuff, you see I'm not in possession of nothing, I'm not. That's what I wanted to talk to you before.
I don't see any information's been filed on the new case. It's set for tomorrow. All right, so we will see you tomorrow, Mr. Rogers, but
We'll be in.
this case will be sent for 6/24. Again, if something gets resolved for all the cases, we can bring it back earlier. That's just the next pretrial conference docket.
Okay, so I'll see you tomorrow. Thank you. And I'll see you tonight after this, I'll be able to speak. Yes, thank you, Mr. Rubin.
as long as they don't send you back, yes.
All right, thank you, Mr. Rubin.
Rubley. Stand on the blue mark next to your attorney. Yes, Judge, please.
All right, this is Caleb Rubley before the court on 25 CF 239. We've reached an agreement in this matter.
All right, appears to be a time-served offer, but that would be a downward departure, is that right?
That is correct, Your Honor, and that would be based on an unenforced plea bargain having to do with the inability to contact the victim after several attempts and some other extenuating.
Okay. Mr. Ruby, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Caleb Charles Rubley, 10/23/98.
All right, Mr. Ruby, you're here in 25 CF 2339, where you're charged with aggravated assault with a deadly weapon and felony criminal mischief. Each of those are third-degree felonies and punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you plead no contest to both of those charges in return to be adjudication of guilt, credit for time served, $666 in court costs. You know I always ask. You have not. Do you need the whole thing?
This was the last minute thing, Your Honor. I need to sign it there.
867.
867.
Thank you.
All right, Mr. Rubley, your total court cost will be $867 plus the $100 PD fee and $50 application fee. Do you understand that?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
And that's the state's agreement already announced, Ms. Flowers? All right. Have you had enough time to go over the agreement with your lawyer?
Yes, sir.
Did you understand and now sign it?
Yes, sir.
All right, and are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
All right, has anyone forced, pressured, or threatened you to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are listed on page 1, and going on to page 2 of the agreement you've understood and signed?
Yes, sir.
You understand you're waiving all potential defenses?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right. And what is your plea to the aggravated assault with a deadly weapon and felony criminal mischief?
No contest, sir.
I'll accept your no contest plea as freely, voluntarily, knowingly given. $867 in court costs, $100 costs of prosecution. Nope. $100 PD fee, $50 application fee. It's adjudication of guilt, so I'll need your fingerprints, Mr. Rubley. Am I saying that right, Rubley?
Yes, sir.
Okay. And this is a downward departure based on the reasons stated by the state on course plea bargain. All right, Mr. Rubley, I just need your fingerprints, then you have 30 days to appeal the judgment and sentence of the court.
Thanks, sir.
Thank you. Have a good day.
Your Honor, I'm going to need a moment with Mr. Rudd.
Okay.
Straight up. Meaning he that's why. So, plead to the bench. You sign it and I sign it, and then that's it. The state doesn't sign it since it's a plea to the bench. Your Honor, this is a plea to the bench. Don't anticipate sentencing today. There is something a little bit unusual that I wrote in there.
Okay.
That, count 1 of the new law violation, the burglary of a dwelling, the state acknowledges that it should probably be reduced to burglary of a structure.
What is it being reduced to?
Burglary of a structure, unoccupied structure, Judge.
Okay. So, I mean, that's part of an agreement then, isn't it?
Right, that's why. There's not an agreement other than.
It's an agreement to modify a charge, but it's not an agreement on anything else.
Correct.
I could.
So that would be a third-degree felony, right?
Correct, Your Honor.
Go ahead, Mr. Sproul.
I could file a amended information before sentencing. So then it's not an agreement.
I don't think it matters if it's an agreement or what we call it. I mean, the only agreement is that it'll be a reduced charge, but as far as what the court would potentially sentence you to, is it Rudd?
Yes.
Okay. There's no agreement that I can sentence you anything from time served to the maximum. You understand that?
Yes, sir.
Okay. And since it's the VOP, which was on a third-degree felony, right? So it's potentially 5 years there. Then there's the burglary of an unoccupied dwelling, second-degree felony, 15 years max on that. And then the modified or amended burglary of a structure, which would be a third-degree felony, so 5 years maximum there. I'm not trying to tell you what I might do, Mr. Rudd, just telling you what your maximum is so you understand that. So you understand when you go to sentencing, I can sentence you up to 25 years in state prison. Do you understand that? Now, I believe from my notes, there was some sort of score sheet issue in the past. Has that been?
It was, the score sheet reflected how it's charged with the burglary of a dwelling. So what I did was reduced it on the score sheet to reflect burglary unoccupied structure.
Okay, so what is his guideline sentence based on that? And Ms. Rivers, have you had a chance to review the score sheet as is with that amendment? Yes?
Yes, Your Honor.
Okay.
I didn't update my offer, like, in my notes, but it's whatever the score is on the score sheet.
That's what you had offered?
Yes.
Okay.
I can let you know what that is.
I just want to know what that number is so I can talk to you about that, Mr. Rudd, so you understand when the guidelines, if they're not objected to, that I'd have to sentence you to that guideline number unless you can convince me at the sentencing hearing there's a reason for a downward departure, and then I should give it to you for that reason.
Yes, sir.
And then it's your burden to prove to the court that I should do that. Do you understand?
I'm not seeing my updated score sheet in my file.
Well, I think in order for Mr. Rudd to give a knowing waiver of his right to plead not guilty, he's going to have to at least know what that number is.
Nothing's in a hurry now.
I mean, it was set in open court last court date, and I've sent it over.
Do you have a copy, Ms. Rivers?
All right. I found it. I had the wrong case number on my docket. I personally made it 18.6 months DOC.
Okay. Do you disagree with that number?
No, Your Honor.
Okay. All right, so Mr. Rudd, just to kind of finish that part of the conversation, you understand that unless you can prove to me a reason for a downward departure under 921.0026, and that you also prove to me that I should give you a downward departure based on one of those reasons, that I'd have to give you the 18.6 months. Do you understand that? I need you to answer out loud. All right, both you and Ms. Rivers are just nodding along, but I need you to answer out loud. Mr. Rudd, so I know this is labeled as a plea and sentencing agreement, but you understand there's really no agreement other than that it'll be that one lesser charge burglary of a structure as opposed to dwelling. Right? All right. Have you had enough time to discuss this with your lawyer? All right, you hesitated. Do you need more time to speak with her about it?
About the charge being dropped?
About anything that we're talking about? The charge is not dropped, it's just being lessened.
Lessened.
But as far as what your exposure is, what you have to prove in order for a downward departure, the enumerated reasons under 921.0026, that you can try to convince the court of a downward departure. Do you have any more questions about that? You want to talk to Ms. Rivers more about it?
Yes, sir.
Okay. Why don't we pass it and see if y'all want to talk about it now, or otherwise we can put it on another date.
Well, he's set for a contested VOP hearing tomorrow.
Okay. So what would y'all like to do?
Or he'd like to be called up at the end.
We'll call you back up, Mr. Rudd, but just to make sure I was clear, the state's offer was the guideline sentence?
It was, but it was revoked when he refused the offer in the last.
Okay, and set up for tomorrow's hearing. Okay. You want me to just hold on to this, or you need this? I'll just hold on to it since there's not anything else I think you'll need as part of it, but we'll bring you back up in a little while, Mr. Rudd, once you've all had a chance to talk.
Thank you.
Saber.
This is John Saber before the court on 25 CF 1769. So. Okay. Your Honor, we're going to request a continuance to 6/24. We want to set this case for depositions.
All right. June 24th, 9 o'clock to set depositions. That will be your next pretrial date, sir.
Okay. Mm-hmm.
Did y'all get this email about Tanner Johnson?
What was that?
Tanner Johnson.
That's an old.
Apparently there's a smuggling contraband charge that should have been part of his pretrial detention case, which we set the bond on. So he doesn't have a bond on the contraband charge, because we weren't aware of it until I just got an email about it. It was Jay, Mr. Williams. Just, we can try to figure it out for tomorrow, but
Yeah, I'll talk to Mr. Kleins. The state will be okay with an ROR on that one, though, based off of the other ones.
Your Honor, this is Toran Chapner before the court on 25 CF 1003, 25 CF 1432. We are going to Your Honor, we're going to request a continuance to 6/24.
all right, what else needs to be done for Mr. Schaffner? Both he's got cases from May and July of last year.
Your Honor, all the depositions have been done at this point. We're just still trying to see if we can work out an agreement with the state.
June 24th, 9 o'clock. I don't expect I'll continue it again if there's nothing new.
Schuman.
Your Honor, this is Michael Schuman before the court on 26 CF 331. We're going to request continuance to the 6/24. We don't have discovery yet, so.
And I apologize for that, Mr. Rivers. You should have it by tomorrow. We've had a few issues.
Do we have a bond hearing tomorrow, too?
That's correct, Your Honor. We do have a bond hearing tomorrow.
And Ms. Rivers, catch me on that before you leave today. We might be able to work something out.
All right, so June 24th at 9 o'clock. Obviously, that may be adjusted as to how the bond hearing goes. He has a bond, right?
Yes, Your Honor. It's a bond reduction hearing.
50,000, okay. All right, Mr. Schuman, we'll see you tomorrow for the bond reduction.
Thank you, Your Honor.
Simmons. Mr. Simmons coming out, seen on blue, coming forward, return case to judge, please.
Your Honor, this is James Simmons before the court on 25 CF 1734. We've reached an agreement in this matter, if I may approach.
Yes, ma'am. Thank you. All right, Mr. Simmons, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Can you state your full name and date of birth, please?
James Calvin Simmons, October 20th, 1968.
All right, and Mr. Simmons, you're here, 25 CF 1734, charged with possession of a controlled substance, third-degree felony, punishable by up to 5 years in state prison, as well as possession of drug equipment, first-degree misdemeanor, 1-year county jail max. Do you understand that?
Sir?
Do you understand that, what you're charged with?
Oh, yes, sir.
Okay. I have a plea and sentencing agreement that I call for you to plea as charged to be adjudication of guilt, 10 months in the county jail with credit for time served. Court cost for a drug case would be?
$650, or, yeah, $615.
$615 court cost, $100 PD fee, $50 application fee, being adjudication of guilt, so that's a felony conviction. Do you understand that, Mr. Simmons?
Yes, sir.
Is that the state's agreement? Will this also be a downward departure?
Downward departure based on uncoerced plea.
Okay. All right, Mr. Simmons, have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it? Did you understand and sign the agreement?
Yes, sir.
All right. Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I do not do drugs.
Are you suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I just read to you?
No, sir.
I have 2 copies of this. 2 copies of the guidelines. All right, do you understand if you enter this plea, Mr. Simmons, there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are on page 1, and going on to page 2 of the agreement that you've said you understood and signed?
Yes, sir.
Do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the possession of a controlled substance and possession of drug paraphernalia?
No contest.
I'll accept your no contest plea. Is freely, voluntarily, knowingly given, adjudicate you guilty, 10 months in the Okaloosa County Jail with credit for time served, $615 court costs, $100 PD fee, and $50 application fee. Judgment on those?
Yes, Your Honor.
All right, your monetary will go to judgment. Mr. Simmons, this is a downward departure based on an uncoerced plea agreement. Mr. Simmons did score 21.375 months. I need you to be fingerprinted, Mr. Simmons, and then you have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
Thank you, sir.
Mr. Smelly.
When you ask questions. You want your discovery too? Okay.
Thank you, Mr. Simmons.
No, I gotta have it to where that's what my wife asked for, so.
Thank you.
Thank you, sir.
Your Honor, this is Davin Smelly before the court on 25 CF 1730 and 25 CF 2247. We've reached an agreement in this matter, Your Honor.
Come on up. The score sheet says 29.625. You have 29.6 months. I'll point out this is the second time today that there's been a plea agreement with a guideline sentence that was off by fractions of a month. I think we just need to be a little bit more diligent on making sure these numbers match up. Just the, all right. Mr. Smelly, you can raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
David Smelly, 07/15/93.
All right, Mr. Smelly, you're here in two cases, 25 CF 1730, where you're charged with burglary of an unoccupied dwelling and dealing in stolen property. Each of those are second-degree felonies and punishable by up to 15 years in state prison. Also, count 3 is grand theft, third-degree felony. In 25 CF 2247, you have a felony petty theft. Those theft charges both are third-degree felonies, punishable by up to 5 years in prison each. Do you understand that? I have a plea and sentencing agreement that calls for you to enter a plea to the burglary in 1730 and the felony petty theft in 2025 CF 2247. It'd be 29.6 months, Department of Correction. I'm sorry, it says 29.625 in one place, but 29.6 in the other. So it's 625, right?
Yes, sure.
All right. All right, then the state would dismiss the dealing in stolen property and grand theft. You'd have court costs, cost of prosecution, $100 PD fees in each case, and a $50 application fee. Is that your understanding of the agreement, Mr. Smelly? Have you had enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your lawyer's representation and advice in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read you? Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are on page 2 of the agreement that you signed? And do you understand you're waiving all potential defenses?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
You understand it's an adjudication of guilt too, so that's 2 felony convictions. All right, and what is your plea to the burglary of an unoccupied dwelling and the felony petty theft?
No contest.
I'll accept your no contest plea to those 2 counts as freely voluntarily knowingly given. State have an announcement on the dealing in stolen property and grand theft.
Those are null pros for plea to the charges.
Okay, those are dismissed. It's going to be 29.625 months in the Department of Corrections. In each case, it's going to be $515 court costs.
Yes, sir.
$100 PD fee in each case, $150 application fee in the 1730 case. Those costs will go to judgment. You do have credit for all time served, Mr. Smelly. You may get a different amount of credit for the 2 different cases because they may They didn't happen at the same time, did they?
No, Your Honor.
Okay. All right. I do need your fingerprints up here, and then you have 30 days to appeal the judgment and sentence. This is a guideline sentence as he scored 29.625 months.
Yes, sir.
All right, thank you, sir. You have 30 days to appeal. Oops. Concurrent, yes.
Smith. Case judge, please, sir.
Your Honor, this is Jonathan Smith in 26 CF 23. We need to do depositions in this particular case, so we're going to request a continuance to the 6/24.
No objection.
All right, June 24th, 9 o'clock. Yes, Mr. Sprouse?
For the defense's, situational awareness, the victim is either on probation or about to be on probation. So that'd be how we find her.
All right, June 24th.
Spice. Case judge, please, sir.
Your Honor, I need just a moment with Mr. Spike.
Wait, we just did Jonathan Smith? Okay, what about Kevin Smith?
So, Your Honor, Kevin Smith is in the DJJ commitment program in Central Florida. We did file a waiver of his appearance. We're requesting 6/24 court date.
All right, 6/24, 9 o'clock.
Your Honor, there was a
Looked like good news.
potential conflict, so I was unable to see him until some decisions could be made. He does plan on entering a plea on this case. However, this is going to be his very first plea agreement, so I really need to sit down and go over it with him in detail, so I'm asking to put this on for Monday.
All right, Monday, May 4th for a plea. We'll see you back on Monday, Mr. Speed.
Sir.
Toledano.
And Your Honor, before we get to Mr. Toledano, there was Mr. Joseph Thompson, that's 24 CF 2424. He did request a waiver, and we did file one after he signed it. We are requesting a continuance on that case. This is the one where we have the new expert working on the material.
All right, new forensic expert. All right, let's get the case moving though, Ms. Rivers. I'm not blaming you for that, but it's from October of '24.
He's frustrated.
I bet. All right, Mr. Toledano, 25 CF 392.
Your Honor, this is Warren Toledano before the court in 25 CF 392. Your Honor, we had done depositions back in December. However, there was one deposition that we did not get completed. The officer was served, but the officer said he was busy working. So we're trying to reset that deposition before we go to trial, and so we are requesting the 6/24 court date.
Without objection.
Case is 14 months old, so let's get that done. June 24th, 9 o'clock.
Mr. Tony.
Your Honor, this is Gerald Tony before the court on 26 CF 361. There were a couple of issues that we had to work out with the state. I believe we're now on the same page, so we're going to ask to put this down for Monday for a plea.
May 4th, 9 o'clock for a plea.
Mr. Trulv.
Your Honor, this is Chapner Trulv before the court on 24 CF 60. We had completed depositions, however, we do know that the state plans on filing a Williams Rule notice. They have a Williams Rule witness. We have requested depositions. We do have depositions set for next week. So at this point.
On the Williams Rule witness?
Yes, Your Honor.
Your Honor, she's also a witness in this case, but she's also being brought in as a Williams Rule witness, so.
So, Your Honor, we're requesting continuance to the 6/24. We anticipate a trial at that time.
Without objection, Your Honor, the depot is set next week.
All right. Again, with the caveat is we only have one trial week next cycle. I would expect this to be one that is set for trial. June 24th, 9 o'clock.
Varnner? Come on out, please, sir. Stand on the floor over there and take the chair, please.
Your Honor, this is Chris Varnner before the court on 26 CF 97. Your Honor, he just had an evaluation yesterday by Dr. Zeman, so we do anticipate a report coming. I had requested 2 different types of evaluations, and I know Dr. Zeman only does the one, is what I'm being told now. He used to have someone that did the second one. But again, Dr. Zeman did text me yesterday that he had completed his portion. But we're going to request a continuance to 6/24/26. If we get any of the doctor's reports in prior to that, then we can bring it to the court earlier for a ruling.
Okay, perfect. June 24th, 9 o'clock.
When I know more, I'll let you know, okay?
Yes, ma'am.
Wagner. Please, stand on the blue X, face the judge.
Your Honor, this is Richard Wagner before the court for 25 CF 895, 25 CF 898, 25 CF 899, 25 CF 902. And, Your Honor, we have depositions that we are trying to set for May or June for 25 CF 898. I believe the focus of the 2 cases that will go to trial next, which one of the 2 will be the 25 CF 902 or the 25 CF 898. As for the 25 CF 902, we've had depositions. Mr. Wagner has conveyed some possible witnesses to me. I've been able to track down one witness so far. The other one, though, is very important that we need to track down to be ready for his portion of that case. So at this point, we're going to request a continuance to the next court date of 6/24.
All right. Do you agree with that, Mr. Wagner? All right, June 24th, 9 o'clock.
Have a good day.
You too, sir.
Wallace. Face the judge, please, sir.
Your Honor, this is Nicholas Wallace before the court on 25 CF 299, 25 CF 531, 25 CF 1818, if I may approach with the state.
Yes. Ms. Rivers?
Your Honor, we're going to be requesting a continuance at this time to the 6/24 docket.
You okay with that, Mr. Wallace? All right, June 24th, 9 o'clock.
Your Honor, this is Jeremy Williams before the court on 25 CF 702. We've reached an agreement in this matter. If I may.
Yes.
Your Honor, may I approach just to check?
I think it was whited out, and it's accurate according to what's on the plea agreement. Trust me, I looked. So you whited it out. So it's just this charge that's on the score
correct,
sheet?
Your Honor.
Okay. All right, Mr. Williams, can you raise your right hand? Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Jeremy Wayne Williams, 10/10/75.
Okay. All right, Mr. Williams, you're here in 25 CF 702, where you're charged with burglary of an unoccupied dwelling, which is a second-degree felony and punishable by up to 15 years in state prison. Do you understand that?
Yes, Your Honor.
I've been handed a plea and sentencing agreement that would call for you to plea as charged. In return, your agreement with the state is adjudication of guilt, 515 court costs, $100 PD fee, $50 application fee, 21 months Department of Corrections with credit for time served, which is what you score. Is that what you're looking to do today? All right. Have you had enough time to go over this agreement with your lawyer? Did you understand and sign it?
Yes, Your Honor.
Are you satisfied with your attorney's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues?
PTSD and bipolar.
Okay. Do you take any sort of medications for that, sir? Okay. Do you feel without your medication that you know what's going on here today?
I know what's going on.
Okay. I just want to make sure that you understand. All right. Ms. Rivers, any concern about whether or not he understands everything?
No, Your Honor.
I'm sure you would have filed something if you did. I just want to make sure because of the diagnosis. All right. Has anyone forced, pressure, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement I've read? Do you understand by entering a plea there won't be a trial of any kind? Do you understand you're giving up your trial rights, which start on the bottom of page 1 and go on to page 2 of the agreement you said you understood and signed? You also understand that you're waiving all potential defenses. And you also understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country. I don't think they're hearing you. I think that's how the new phone rings, maybe? Hey, Reagan. Can't hear him? Okay, thank you. Just make sure you're speaking to that phone, huh?
Yes, Your Honor.
The first time the new phone rang, it has a different ringtone, I guess. I had no idea what that was. Sorry about that, Mr. Williams. Just make sure you're speaking to the microphone. They just called because they're having trouble hearing you on the recording. All right, and I think the last question was, and you answered it, but just to make sure, because the ringing was there. Do you understand if you're not a U.S. citizen, that this could lead to your deportation or exclusion from the country?
Yes, Your Honor.
All right. And what is your plea to the burglary of an unoccupied dwelling, second-degree felony?
No contest.
I accept your no contest plea is freely, voluntarily, knowingly given, adjudicate you guilty, sentence you to 21 months in Department of Corrections with credit for time served, 515 court costs, 100 PD fee, $50 application fee. Those will be sent to judgment. This is a guideline sentence as you scored 21 months. I need you to be fingerprinted, Mr. Williams. And you have 30 days to appeal the judgment and sentence of the court. Thank you, sir. Good luck. I'm watching YouTube over here. What's going on?
Your Honor, this is Jaden Windgrove before the court on 25 CF 2428. We currently have depositions set for June 17th. We are requesting continuance to 6/24/26.
Any objections?
No objection, Your Honor.
All June 24th at 9 o'clock for pretrial. Thank you.
Did you want to speak with Rosa and Attorney Clymer?
If I could, with him and Mr. Rogers. If he's still here. If not, that's okay.
Joseph Carroll refused to be transported.
Judge Charles Russell, Public Defender's Office, Joseph Carroll, case number 24 CF 2383. I did speak to Mr. Carroll this morning and explained to him what I would do. If the court will recall, he recently received a similar type charge that I think is set for felony plea day tomorrow. I anticipate that the state at some point is going to try to Williams rule that case into mine or vice versa, or both ways. So I'm going to ask for a continuance on my case based on that, and we've got depots set of witnesses already in this case set for June 9th.
June 9th, I'm looking at that now.
Yes, sir.
All right, 6/24 at 9 o'clock for pretrial, but we'll have you back tomorrow for the new case?
Actually, Mr. Max is going to handle the new case.
Okay.
Thank you, Judge.
Thank you, Mr. Russell. Is that all you had? Waited all afternoon just for your client not to show up?
Robert McDonald also refused. If you want to address that, and we'll get the other ones that you have lined up.
Judge Robert McDonald, the court heard a number of motions to recuse on the cases that he was pro se. There was another case that I can't recall what the issue was, but it wouldn't have been granted under the regular motion that he'd filed, but the court self-recused. And then I've got two cases with him, and I think the court mentioned that his motions were not through counsel. Judge, I can't join those motions because I can't sign the affidavit. I didn't hear the conversation that he's claiming took place because they weren't on my cases.
Okay.
But I do think that it's appropriate for them all to be handled before the same court. And what I was thinking the court might want to do is go ahead and just self-recuse on those.
So let me just make sure we've got the last ones. It's going to be 25 CF 2441 and 2442.
Judge, that's what I'm thinking, but hang on, let me confirm it, because we don't want to.
Because I agree with you, and that's basically why I recused on the cases. I couldn't just grant his motion to disqualify.
Yes, sir. Yes, sir. I've got, mine is 25 CF 2441 and 2442.
All right, what I'll do is just issue orders recusing myself from those cases so they can all be done together. I'm not sure who he ended up in front of, if it was Judge Stone or Judge Clark, but.
I think they were set in front of Judge Stone, but I could be wrong. The other cases were.
All right, I'll go ahead and put them on June 24th.
Yes, sir.
Just as control, and then I'll file orders recusing myself in those two cases.
Now, Judge, let me, before you do that, let me ask you, it looks to me, reviewing the clerk's docket, that there is correspondence in the clerk's file that was not received by my office. It looks like you put it maybe in the wrong envelope. It reads like it was supposed to go to me. I don't know that it mentions me.
It says Mr. Williams and then starts going.
then, Judge, I'd ask that that be sealed.
Well, I guess the issue is if I'm recusing myself, how am I making decisions on things like that?
Yeah. Judge, I can.
I mean, I want to be
notify
difficult,
whoever
but
takes over. I don't recall.
if someone asks me to disqualify from a case or recuse from the case and then ask me to do that, I'm not saying you're doing that, Mr. Williams.
Yes, sir.
But you can certainly bring that up with Judge Stone.
Yes, sir. I anticipate actually it'll go to one of the South End attorneys now.
Okay.
Got your females lined up?
Okay.
Keebler's the first one out the door.
All right. Oh, I understand Keebler's out the door. Ms. Heiker actually comes before Ms. Keebler, but she's not been transported because she's ill. Judge, I spoke with the state about this. I think the case is going to go away, but we need to put it until Monday.
That's Ms. Hiker?
Yes, sir. Heather Heiker, 2013 CF 1808 and 26 CF 78. And that'll be plea or continuance there.
We'll put her for 5-4 plea or continuance. All right, Ms. Keebler.
All right, Ms. Keebler, let me switch over to you. Okay. Judge, I'm going to ask to continue the case. No?
Take the offer.
Oh, you want to take the offer? All right, just one second.
Are you able to get credit for time served?
Yes, yes, you're entitled to credit for time served. Ms. Keebler, I'm sorry, I did not type that up yet. Give me a few minutes. We'll pass you the end of the docket, and I'll get it written up for you, okay?
Thank you.
Okay.
Catherine Hughes. Ms. Hughes?
Ms. Hughes already entered her plea, didn't she? No, we didn't. We didn't call you up. We talked about it, and then we went to lunch. Come on out. Yeah, come on out. Sorry, Judge, she was on my first to see list, and I thought we'd done her earlier. Judge, this is going to be a negotiated plea.
Okay.
Here we go.
Is there some other kind of court order about contact?
Judge, I believe a divorce has been filed. I haven't seen the paperwork yet, but on the videos, there's some discussion that she had filed for divorce. And so that's the reason for me phrasing it this way, is that at some point, they're going to be in a room for mitigation or for mediation purposes, sorry, Judge. And there's a family pet that she's hoping that if the judge doesn't let her have the pet, then certainly it would, she's hoping it'd be.
Well, there's currently an injunction in place, too.
Well, she'll have to go through that, Judge.
I'm just seeing if there's an easier way to word it, but.
I see, yes, sir.
All right, Ms. Hughes, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
Can you state your full name and date of birth, please?
Catherine Edith Hughes.
And Ms. All right, and Ms. Hughes, you're here in 26 CF 201, where you're currently charged with aggravated assault on a victim over the age of 65, as well as battery on a law enforcement officer. The first charge is a second-degree felony, punishable by up to 15 years in state prison. The second one, a third-degree felony, punishable by up to 5 years in state prison. Do you understand that?
I'm sorry. Yes, sir.
All right, thank you. All right, Ms. Hughes, I have a plea agreement here that calls for you to plea as charged. It'd be a withhold of adjudication, 3 years of probation, special condition, 90 days county jail, credit for time served, $967 in court costs, $150 PD fee. You're to have no contact with Daniel Hughes except through counsel. It says or court process. What is?
Well, Judge, for example, if the court...
If she has to attend court, she's allowed to be there. All right. I just want it to be clear so there's not some reason to violate it. So you can have contact through counsel, your counsel, and you're both represented, right?
Right.
Okay. Can talk to each other about the case. That wouldn't be a violation. You can attend court dates or mediation or anything like that that's relative to your court date without violating, but again, you can't have contact out in the hallway, during the court, if there's a recess of the court proceeding, you can't start yelling at them in the hallway. You understand that, right, Ms. Hughes?
Yes, sir.
I guess part about, unless victim requests it in writing, is that to probation?
Yes, sir.
Okay. So no contact would continue unless the victim, Mr. Daniel Hughes, gives a written statement to probation asking for that to be done, and I would allow probation to allow at that point. I think the problem with writing it up that way is, how does that get into the court's order for purposes of, for example, law enforcement gets called out, probation says it's okay, but there's no court order that says that, and then the police say, well, we don't see a court order that says you're allowed to have contact, and it's one of those, you may beat the rat, but you won't beat the rod kind of situation. I don't want her to get arrested and then it finds out that she could have done that based on what the court order was at this point and then modified by probation, but the police don't see that on the street if they get called out. I've got some real concerns on how this is worded that could potentially lead to Ms. Hughes being arrested for something that even the victim wants to have happen.
Judge, if I'm open to suggestions on a better way to word it.
I think it should be a motion to modify it. Otherwise, if there's no court order, that's what law enforcement looks at when they come out to a house and there's people having contact, which the current order says they shouldn't have, they can't have contact. And frankly, Ms. Hughes, I'm doing this not only to protect you from accidents, but from any attempt for someone to do that purposely to you.
Yes, sir. Thank you.
So how do y'all want to word this?
I'm trying to make it easier for the parties.
I understand that, but easier doesn't always mean better.
Yes, sir. Yes, sir.
All right. So what I would say is no contact except through counsel or attending court proceedings, including mediation. If the victim wants a change, he's going to have to file something that will have to come before the court through a motion to modify. So this part about facilitating property exchange, that can potentially be done through the lawyers.
If I've tried to draft this in such a way that the family law court could, for example, if the family law court ordered that the time essentially be time sharing with the pet, that they'd be able to do that without having to come back.
I don't know who the case is in front of, but typically they don't do time sharing with pets.
I understand. My ex and I did with ours, but we did that on our own, but there were no...
There was no probation and aggravated assault charges in your case, I would guess.
I'm just trying to accommodate the client's ability to negotiate.
It's very ambitious, Mr. Williams.
I will say, I spoke with the victim in this case. He doesn't have any intention of having contact with the victim. That's why the offer was given the way it was.
All right. This is the way I'm going to say it. No contact with Daniel Hughes except through counsel or attendance of court-related proceedings or mediation. As far as anything to do with property exchanges, and frankly, under the law, that includes pet time sharing, that would all have to be done by the family court, but you can't have any contact with them, ma'am. You're not going to be texting back and forth about, can I pick up the dog at 6 o'clock? Because he doesn't want contact. That can always be changed with a motion to modify your probation. Again, Mr. Williams, I think it was ambitious, but it's just, it's trying to do too much, given that there's also an injunction in place and there's a family law case in place.
I can't see the dog.
All right, I'm gonna let y'all talk about this. I just,
Okay.
and I'm not, I'd like for this to get resolved today, Ms. Hughes, but I can't do it in a way that it's so convoluted that you're gonna end up getting arrested because you were trying to see the dog. And I'm not trying to be flippant or offensive in any way. I really don't want to see it happen. I've seen it happen, which is why I know to look out for it.
I understand.
All right, so Mr. Williams will come back and talk to you, and we'll bring you back today, since, does she have the credit to get out today?
Yes, she does, Judge.
Okay.
She's got about 120 days.
Okay, we'll get it figured out. I just want it worded in a way that everyone feels comfortable, and it's not, because if I put in the plea agreement this way, we have to really make sure it's spelled out so that we don't have any other issues.
Thank you.
Because I can't tell the injunction court what to do. Typically, they wait for the criminal case to be over with, but I can't tell them, change the injunction to say X, Y, or Z. So I think it's best that it's, well, I don't want to say that because then you're going to do whatever I say, and that's not what my position is in this particular situation. But talk about how you want it spelled out, Mr. Williams, and then we'll address it later today.
I'll try. I don't know that we're going to be able to do it the way that she wants it done today.
Okay. I can't tell the family law judge what to do. Just like when I was in family law, I wouldn't have let the criminal judge tell me how to handle my family law case. There has to be some separation.
I understand, guys, just trying to make it possible for
Again,
that to take place.
ambitious, but I'm not sure it's going to work. That's not going to end up leading to Ms. Hughes getting arrested for something that wasn't intended.
Well, if I understand, just so that I'm able to draft it up in a way that's acceptable to court, are we contemplating the idea that there would be a motion to modify in order to affect pretty much anything along those lines?
Yeah, I think she's allowed to attend court dates. She's allowed to go to mediation, which are typically done on Zoom nowadays. So there wouldn't be any direct contact. But as far as property exchanges, issues with animals, it's not really easy for the court in this position to direct all those different things. Whether or not there's a contempt of court, indirect contempt of court in the family law case is one thing. When law enforcement can't see it in an order that's in the court files, she's going to end up getting arrested for things that weren't intended. And that's what I'm trying to avoid. You're welcome.
My concern is that typically on motions to modify, I hear the state coming in and saying, this is not what we agreed to. So as long as we can find some way to accommodate that situation, I think we can draft it up as just a separate motion.
I'm not going to get into the weeds of time sharing with pets in criminal court.
Yes.
So if that needs to be done, The family law court judge can put that in his order, and then y'all can come back to me with that order and say, this is what was decided in the family law court, usually based on the other side saying, yes, I'm okay with that. But otherwise, it's no contact.
I understand.
I mean, I'm not saying anything about what happened. You're trying to enter a plea to an aggravated assault against this person. They have the ability to say, I don't want to have contact with that person anymore. As far as animals or property, that's for that court to figure out.
Judge, what she's asking about is essentially the one-time visit that I indicated.
And that can certainly be done once it's agreed upon, what the property the distribution is.
I have no clue.
Well, she's talking about in order, now you're going to have to do it also with the injunction court, okay?
Okay.
But what she's talking about is getting a driver's license, clothing, things along those lines. She was arrested on scene.
Okay, I can understand the one time right away for that stuff, but it's not going to be go back every time they just decide. I understand what the situation is, ma'am. I'm trying to prevent you from getting arrested.
Yes, sir.
As far as going back one time, now, sure, you can do that to get some clothes, your driver's license, tools of the trade, if you work and have things in the house that you need. But it's not going to be a going back and forth. Now I'm picking up my china set. Now I'm picking up the living room couch. That's not what we're talking about here. And I don't think the family law court is going to go through all those things with you. There has to be kind of a global decision made on all these things. And it's not for criminal courts to micromanage what happens in your family law case.
I understand.
All right, talk to your lawyer, Mr. Williams, and I'll tell you this because, so he doesn't have to. He's appointed to your criminal case. He can't give you advice on your family law case. His office would have an issue with him doing that.
Yes, sir.
Okay?
Yes,
So
sir.
all he can do is what's right for your criminal case and then hope it works out with your privately retained family law attorney, right?
Right.
As far as those things go, you have to talk to Mr. Brannon about that, right?
Yes, sir.
Okay.
Okay,
Thank you, Ms. Hughes, we'll recall you.
Thank you.
Your Honor, if I may be excused, I think one of my cases are done for the day.
Good for you. Thank you, Mr. Sheik.
Do I leave now?
Mr. L.
All right, Judge, I don't know if you've seen it yet.
I have. The competency evaluation? I'm sorry, I shouldn't have interrupted you and assumed what you were saying, but go ahead.
This is, I should have announced the case, Judge. It's Ronald Allen, 2021-967.
Okay.
So we wound up with a rather cryptic notice from another counselor dealing with the potential for a conditional release plan and some other things, but it wasn't really the second evaluation. Dr. McDonald emailed over the second evaluation around 1:30 this afternoon. Both myself and Mr. Sprouse have taken a quick look at it. It's an agreement on whether or not he's competent, but it's not an agreement on what should happen with him next. So what I'm going to suggest is we set him for a competency hearing. I think the next miscellaneous date is May 28th. And the only other thing I think I'd need is maybe some guidance from the court, where the court would prefer that we have both of the psychologists there so that they can answer any particular questions rather than just stipulating the reports. I'd suggest if we do that, we do it by Zoom just to try to accommodate the psychologist.
And the state would stipulate to that.
What was the other report, the first one? I don't see it in the file.
I've got a copy, Judge.
It seems pretty clear to Dr. McDonald what needs to happen. I just don't have access to the other report.
Do you have a copy already?
Yes.
Of Siemens?
So one from last month?
That's Dr. Siemens' report. This is the one from Ms. Varela.
I've got Ms. Varela's report, and I've got Dr. McDonald's report. I don't have Dr. Siemens' report, at least not where I can see it. Although it goes all the way back to December. I think it's listed in here as reciprocal discovery, but it wasn't attached, which is fine. I just want to see what it says. So I think we did have a competency hearing back in January, and that was the issue, is what do we do next?
Yes, sir, and if I recall correctly, Ms. Leone asked to have a second expert, and we've just been trying to get that report.
All right.
Which raises actually another question.
What's your further question, Mr. Williams?
No, have not been thinking in terms of a quote-unquote tiebreaker because they're in agreement on the competency issue. But I don't know if the court wants to appoint a third to determine the question of whether or not he meets criteria for involuntary hospitalization. Based on the report from...
Well, one says he's unrestorable.
Yes.
And the other report says he needs to get back on his medications, which he's refused for months. Frankly, it says from Dr. Zeman, given his compliance with psychiatric treatment, in my opinion, he should be considered unrestorable. So is he compliant or is he not compliant?
No, I think he was compliant with Dr. Zeman. And I noted in the other report, not very helpful for me to describe it that way, the report from Dr. or Ms. Varela.
Who's present?
Oh, okay. She's,
I just met her today too, so.
well, she talks about speaking with the staff at the jail that seems to be indicating not an issue. And that's one reason why I'm thinking maybe we need to have a more full-blown hearing on it.
All right, let's set him for a hearing.
Do we have space on 528? Or do you want me to just have my secretary get it set?
I think we can do 528. Say again.
The state has no issue with
All right,
528.
let's do May 28th at 9 o'clock. I think having the doctors appear by Zoom at least to take questions, because I think that's part of the problem sometimes, is there's no give and take between their opinions. We just have to read them cold and kind of try to figure out where they don't match up. And although ultimately it's the court's decision, I'd like to be as well educated on the particulars of Mr. Allen before I can really make that decision.
Yes.
Because I do read in Dr. Zeman's report, that Mr. Allen has been at the Florida State Hospital for some time because of this case, but it sounds like when he came back, he'd stopped taking his medication, and that's the problem. And frankly, if he's in the jail and if he's not getting his medication there, or, I don't know, and that's what I really need to know, the details of it, where one person says he's compliant, the other one says he admits that he's not compliant.
Can I speak, Honor?
You can talk to your lawyer, Mr. Allen.
You can go ahead and tell the judge.
When I was at Florida State Hospital, Judge, I went to med court, and the judge at med court told the nurse practitioner that was trying to put me on medication not to put me on medication, and she got mad and put me on medication anyways. So I'm just going by what the judge at med court said, not to put me on medication. That's why I'm not taking no medication now.
All right, I think it's gonna have to be a hearing. We have to bring them in and listen to what they have to say and make decisions from there. Obviously, if there was some other opinion, I'll potentially take a look at that too, but.
Judge, my next question is just, are you sure you want it at 9 a.m. as opposed to?
Did I say 9? Should be 2 o'clock.
Thank you, Judge. We'll do up the notice of hearing.
All right.
All right, thank you.
All right, thank you, sir. May 28th, 2 o'clock.
Hey, Mr. Wright.
Judge, I filed motions to suppress in the case. And I've asked my secretary to schedule it for a hearing. I think the next hearing date is going to be May 20th.
State have any issues with that?
No, Your Honor, I don't believe Ms. Leone had received those yet. She said she was waiting on it. So we'll double check on that. But if it's set for the 28th, that should be no issue, Your Honor.
Let's see. Is it in bulk? I see one was filed on the 27th.
There should be one in each case, Judge.
Okay. There is one in each case. I haven't reviewed them to see how different they are or anything. I didn't know about them until just now.
Identical.
Oh, okay. All right, so you want to do May 28th at 2 o'clock for those?
Yes, sir.
All right. So pretrial on June 24th?
Yes, sir.
All right.
Thank you, Judge.
See you back on those dates. Yes, ma'am.
Oh, there was one other we were going to talk about, Calvo. Judge, Ms. Leone was going to handle Calvo, set for sentencing tomorrow. She asked if we had any objection to continuing it. I talked with the client. We do not.
In all candor, I started looking at tomorrow's 2 o'clock docket during lunch today, and I saw that one. It's been a while, because I think he was in Escambia County for a while.
Yes, sir, and I believe Mr. Williams may have witnesses as well. That's why I wanted to go ahead and address it today. We have no objection to that being continued. Obviously, Ms. Leone did want to handle it, but I could if the court wanted.
That's fine. No, we can continue. What date would you like to put that on? Sounds like May 20th at 2 o'clock is quickly filling.
Court's discretion on it. My client's out of jail, so
He is?
like we're delaying things.
Hold on a second.
He was serving a sentence in Escambia. That's been
No,
resolved.
what happened, he pled to a new charge. I'm sorry, he pled to these cases, it was set for sentencing. While his sentencing was pending, he got arrested for DUI, I think, in Escambia County.
I'm not sure when the DUI occurred, Judge. I just know that he was arrested then. So I don't have any further information on the DUI because I wasn't involved with it.
Understanding is, now that I'm looking at it, he pled on November 3rd. In this case, it was set for sentencing on January 8th. He was then arrested in Escambia County for DUI and drive while license suspended on November 19th. So 16 days later. And he had been in the jail in Escambia County ever since. On January 7th, he pled to the DUI. So he was arrested for and pled to a new crime while awaiting sentencing. I guess I'll say this before we decide if you want to continue it tomorrow. I'm going to be issuing an order to revoke his bond and put him into custody.
Yes.
And so I don't know if you want to try and reach out to him in the meantime. It's my understanding he was still in custody.
That's what we thought too, yeah.
I'll contact him, Judge. I don't know that it'll make any difference, but if the court wants, I'll contact him. Although I anticipate that as a result of the state's request, the court's likely to give them a continuance anyway.
Was he given notice for tomorrow's hearing?
Judge, I've spoken with him about it.
Okay.
I don't know that I
And there's a notice of hearing that was done by your office.
Yes, sir.
All right. Then we'll see.
He and I've talked about it several times.
Then we'll see him tomorrow.
All right, Judge.
I'll entertain any motions to continue by either side tomorrow, but he needs to be here.
Yes, sir.
All right, next.
Horn.
Judge, this is Charles Horn, 2024 CF 811. Judge, I spoke with Dr. Zeman. Dr. Zeman is meeting with Mr. Horn Monday. We provided Dr. Zeman the records that he's requested as well as the court smart video initially.
That's the second evaluation.
That is, Judge, you had initially appointed, I believe on the court's own motion, Dr.
McDonald, who opined he was competent.
Yes, sir. And based on everything, including court on that occasion, and I felt like it was appropriate to ask for the second evaluation so it would not be any concerned that I had simply accepted another doctor's word for it. If you'll recall at the jury selection.
I remember. At the jury selection, he kept acting like he didn't know what was going on. All right. This needs to be resolved with a competency hearing through the next cycle. This case is 2 years old.
Yes, sir.
We've had motion hearings, we've had it set for trial. If it's a competency issue, it needs to be resolved.
Yes, sir.
June 24th.
June 24th.
All right, this is State of Florida versus Michael Lynn Jackson Jr., 24 CF 5826 CF 229.
Yes, sir. Judge, Mr. Jackson informs me that he's got the older case, and then he's got the new trafficking case. Court issued a ruling on motion to dismiss, motion to suppress on the older case.
Yes.
He's advised me that he's going to hire private counsel.
Have you hired private counsel, Mr. Jackson?
No, sir, I haven't done so yet. I need to get an attorney-client privilege. The law firm doesn't accept jailhouse inmate calls, and they need to speak with me so that they can release the funds to the proper person and ask a few questions. And
Well, when is that going to happen? Your case is over 2 years old.
yes, sir. I hopefully today or tomorrow or whenever. I don't know if how long it's going to take for the jail to facilitate a call for me. So I really couldn't say. But
The attorney's not willing to come see you?
I haven't spoke to the attorney myself because they haven't been up here. I haven't hired them yet. I'm just trying to get the funds released.
What do you mean the funds released?
Well, it's a law firm. It's a law firm in Virginia, and the law firm is I have a personal injury settlement case that's closed out, and I just haven't received the funds. I've been here the whole time, and they're trying to figure out where to transfer the funds or what.
So you haven't talked to another lawyer to represent you in this case?
I have a third party advocating for me outside, a friend of mine. And
I'm going to ask you to answer my question, please.
I haven't, not myself, but I have somebody's talked to a lawyer for me there, Risa Dudley, yes, sir.
Okay, I understand, but here's the problem, Mr. Jackson. Your case is over 2 years old.
Yes, sir.
It's ready for trial. So if another attorney comes in and says, I'm going to represent him, that's fine, but you can't just tell us, I'm going to have another lawyer, so I need to continue it again. It's 2 years old.
Oh, no, sir, I wouldn't try to stall the court out or nothing like that. It's a legitimate thing. It's, I can tell you the name of the law firm and everything, and it's, I haven't been able to acquire the attorney-client privilege phone call to be able to contact them to release the funds. That's the only thing holding me back.
And when did those funds become available?
Whenever I talk to the firm and get them to release it.
When was the settlement done or whatever that got those funds to begin with?
Well, the case has been open for 6 years, so.
Again, that's not the question I asked.
Okay.
When did the case finish?
I couldn't tell you exactly what day it is, sir, because I've been incarcerated the whole time, so I don't know.
Today is April 29th. It's a Wednesday.
Yes, sir. Oh, yes, sir. I don't know when the case closed. I just had a third party advocating for me, and they told me that they need to speak with me so they can.
I'm going to put you down for Monday for plea or trial. You have some information for me. We'll talk about it on Monday. But I'm not going to, after 27 months, say you might have access to some funds, but you can't talk to anybody about it as a way to delay this case any further.
No, sir, that's not what I'm trying to do. Yes, sir, I understand.
Well, I'm telling you what my intent is to have this case resolved.
Okay.
You've got one pending trafficking case that's 27 months old, and you have another one that's only 3 months old. One of them is going to be resolved. I've noticed throughout my 22 years practicing law, when deadlines are given, people actually get up and do something. I'll see you on Monday, Mr. Jackson.
Next will be Cohen. Cohen, Jackson, stand in your spot.
Mr. Cohen.
Did we do Keebler already? I think so. She came out, I wonder if we finished it.
We did.
You gotta write it up, okay.
Yes, sir. She decides you want to take the.
That's what I couldn't remember.
All right, Judge, this is William Fred Cohen, 2024 CF 213 and 26 CF 213.
I think it's 24 CF 2396, 26 CF 213. Gotcha. Go ahead.
Sorry, Judge.
It's fine.
In any event, Judge, I'm going to move to continue the case. We've made actually, I don't know that I've made the counteroffer as yet. But we've got a counteroffer we're going to make over. I don't think it's going to be possible to get it resolved this time, but.
What's the counteroffer?
This is the one that was community control. He's trying to resolve it with community control. He'll do, whatever else along with that he needs to do.
There's a minimum mandatory 3 years.
You'd have to plead to something lesser. Otherwise, I have an idea on how to deal with that, but it's something that you and I would need to discuss, and I need to discuss and get more details from him before you're going to want to talk with me about it.
I mean, the offer's 3 years.
But I don't have any detail.
Do that.
Well, and obviously, we would talk.
Do you want to try to talk about it for Monday?
Judge, can we approach on? I think it'll make more sense.
June 24th, 9 o'clock.
Thank you, Judge.
Mr. Lee. Maybe, no, what's your name, sir? Ingram? Okay, we'll find Lee in a second. Ingram, come on in.
Was it?
Stand on the blue mark, sir.
Judge, this is Marcus Ingram.
Did we handle this already?
Yes.
The state's already made an announcement in your case, Mr. Ingram. They've dropped the charges.
Yes, sir.
Okay, your case is dismissed. I thought y'all told them that they didn't have to bring him.
I did. He was the one person standing in the feed, so I was going to figure out who was.
Your case is dismissed, Mr.
Yes,
Ingram.
sir, thank you.
No, you don't need to sign anything? Yeah, you should get everything back, but
What did I get?
when you go to the jail, they'll give you whatever property.
As long as it's something you're legally allowed to possess.
Tennis shoes. All right, can we move on?
I'm waiting for the next one to get a beat.
Let's just- shoes back.
Lee?
All right, we've got Dominic Lee, 25 CF 944 and 25 CF 2141.
This is Dominic Lee. Judge, we are still trying to get depot dates from the state on the new case. I'd like to handle the two cases together. So I'm going to just move to continue.
State?
They need without objection.
All right. Understand that, Mr. Lee?
Yes, sir.
Be June 24th, 9 o'clock. Let's get this deposition set and done before that date.
Yes, sir. We're just waiting for a response with the dates.
Okay.
Thank you, Your Honor.
Thank you, sir. Have a good day.
Livingston.
All right, Michael Stephen Livingston, this is 25 CF 2113 and 2114, also 2115.
Judge, I'm going to move.
And, I'm sorry, 25 CF 2437.
Yes, sir. Judge, I'm going to move to continue these. I'm wanting to get them all resolved at one time. We're trying to find some alternative sentencing. We got turned down by one place. We're reaching out to two others. Plus, Mr. Livingston's asked me to check his score sheet, so I'm going to compare it against CCIS and see if I can get it straightened out.
All right. State. All right, June 24th, 9 o'clock for Mr. Livingston.
All right, sir. Mr. Marshall.
All right, Mr. Marshall is here. Andrew Marshall, 25 CF 1667 is a VOP, 26 CF 191.
Judge, it looks like this case was heard or arraigned on 2/26 and set directed today. I'm going to move to continue the case. Mr. Marshall, your counteroffer was declined, so we'll have to come up with something else.
All right, June 24th, 9 o'clock.
Mattingly. Yes, sir.
This is James Brandon Mattingly, 25 CF 1642.
Yes, Your Honor.
All right. Mr. Williams?
Judge, what I'd like to do is set this for docket day for plea or continuance. The state and I have gone back and forth on some offers. I need to run some possibilities with it.
All right, Mr. Mattingly, we'll see you on Monday. That's May 4th, this coming Monday, for plea or continuance.
Okay, thank you, Your Honor.
Thank you.
Judge, I think the next one's going to be Mr. McGovern.
Be McGovern.
Clovis McClellan, we handled him this morning. He was out of jail.
Yeah, we put him on 622.
May still have mine. Jen, I think you've still got.
Oh, do I have?
I've got a score sheet.
I printed a score sheet as well.
Judge, this is Brian Lee McGovern, case number 4625 CF 2064. There's a negotiated plea and a score sheet.
All right, Mr. McGovern, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
Brian Lee McGovern, 09/27/1998.
All right, Mr. McGovern, you're here in 25 CF 2064, where you're currently charged with resisting an officer with violence, third-degree felony, 5 years state prison maximum, as well as possession of drug paraphernalia, a first-degree misdemeanor, punishable by up to a year in county jail. Do you understand that?
Yes, sir.
I have a plea and sentencing agreement that calls for you to plead as charged, be an adjudication of guilt, 3 years of probation on the felony count, with bars to bed to the Chrome drug program, no controlled substances without a prescription, random UAs, may seek early term after a year and a half. That's a may seek early term after a year and a half upon successful completion of the program with no violations. It's just time served on the paraphernalia.
Yes, sir.
Time served on the paraphernalia. Court costs $515, $150 PD fee, waive cost of supervision. Is that what you want to do, Mr. McGovern?
Yes, sir.
Is that the state's agreement? All right, it appears to be a guideline sentence. Mr. McGovern, did you have enough time to go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Okay. And are you satisfied with your lawyer's representation and advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've just read you?
No, sir.
Do you understand that if you enter a plea, there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are listed on the document that you understood and signed?
Yes, sir.
Do you understand you're waiving all potential defenses?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the resisting with violence and the drug paraphernalia?
No contest.
I'll accept your no contest plea. It's freely, voluntarily, knowingly given. Adjudicate you guilty, place you on 3 years of probation on the resisting with violence charge. That's the felony. Time served only on the misdemeanor. It's going to be bars to bed, which means you'll stay in the jail until the Chrome program can get you.
Yes, sir.
You're to successfully complete that Chrome drug program. No controlled substances without a prescription, random urinalysis. You may seek early termination after 1.5 years upon successful completion of the program with no violations. $515 court cost, $150 PD fee. This is a guideline sentence as you scored 33.6 points. I need you to speak with probation, who's sitting behind you, and then be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court, Mr. McGovern.
Yes, sir.
Thank you.
And I've notified Chrome that you're being sentenced today, so